public bodies will be served by opening the doors to the particular forum in question. End of quote. I am in respectful agreement with these statements. Section 9, 1 in brackets, B in brackets of the National Prosecuting Authority Act, 32 of 1998, in brackets the NPA Act, requires of the President to appoint someone who is, quote, a fit and proper person with due regard to his or her experience, conscientiousness and integrity, to be entrusted with the responsibility of the office concerned. End of quote. The NDPP is required to be independent and to be seen to be independent. See Section 179(4) in brackets of the Constitution. In Corruption Watch NPC versus President of the Republic of South Africa, 2018, 2 SA 442 CC in brackets, the Constitutional Court said the following with regard to the independence of the NDPP in paragraph 19 of its judgment. Quote, this court has said of the NPA's independence, open single quote, there is a constitutional guarantee of independence, and any legislation or executive action inconsistent therewith would be subject to constitutional control by the courts. The reason why the guarantee of independence exists is not far to seek. The NPA plays a pivotal role in the administration of criminal justice. With a malleable, corrupt and dysfunctional prosecuting authority, many criminals, especially those holding positions of influence, will rarely, if ever, answer for their criminal deeds. Equally, functionaries within that prosecuting authority may, as CASAC submitted, be pressured into pursuing prosecutions to advance a political agenda. All this is antithetical to the rule of law, a founding value of the Republic. Also, malleability, corruption, and dysfunctionality are at odds with the constitutional injunction of prosecuting without fear, favor, or prejudice. They are thus at variance with the constitutional requirement of the independence of the NPA. End of quote. It is a matter of public knowledge that the office of the NDPP has been plagued for a number of years by instability as a result of previous appointments of national directors which have been made. The applicant contends that this is precisely why the interviews must be conducted in public. To shut the public out of this important process will further erode public confidence in the integrity and independence of the NDPP and the NPA. I agree with that submission. In Glenister versus President of the Republic of South Africa and others, 2011, 3 SA 347 CC, the Constitutional Court dealing with the independence of the Hawks said the following in paragraph 207 of the judgment, quote, this court has indicated that the, open single quote, appearance or perception of independence plays an important role, close single quote, in evaluating whether independence in fact exists. This was said in connection with the appointment, procedures and security of tenure of magistrates. By applying this criterion, we do not mean to impose on Parliament the obligation to create an agency with a measure of independence appropriate to the judiciary. We say merely that public confidence in mechanisms that are designed to secure independence is indispensable. Whether a reasonably informed and reasonable member of the public will have confidence in an entity's autonomy protecting features is important to determining whether it has the requisite degree of independence. End of quote. The process which the President has directed to be followed is a big improvement on the procedure which was followed in the past. when national directors of public prosecution were appointed by the head of state without any election process being followed. But the President has not given any reasons why he has decided that the interviews of candidates should be closed to the public. Having decided that an inclusive process should be followed, that process should be open and transparent. The public cannot be expected to have confidence in the independence and the fitness and propriety of the candidate who is selected without any information about the interviews of the shortlisted candidates being made available. It is of utmost importance that confidence in the office of the NDDP be restored. To this end, an open and transparent process which will provide the public with information regarding the interviews must be followed. For these reasons, I am of the view that the application must succeed. I am satisfied that the limitations proposed by the applicant in its notice of motion strike an appropriate balance between the rights of the public in terms of sections 16(1)(a) and (b) of the Constitution and the purpose being pursued by the President. Mr. Winks, have you and your colleague discussed the issue of the number of media representatives?
My Lord, I believe my learned friend may have some information.
Oh, I see. Mr. Malindi, have you got information on that?
My Lord, we took instructions and we are advised that the room that was available for these interviews would not accommodate one person more, but that if your Lordship gives an order of, even in terms of the notice of motion, arrangements will be made to accommodate.
Thank you, Mr. Malindi.
And my Lord, we might add that that process of finding an alternative venue will not be completed tonight, so the proceedings will be not commenced tomorrow.
What won't be completed tonight?
The process of interviews will not commence tomorrow while the suitable venue is being arranged.
I follow.
Thank you. As the court pleases.
I've just completed the particulars in the head note of the draft order by inserting the case number, etc. An order is then granted in terms of the draft order, which I have marked X.
As the court pleases.
As the court pleases.
Yes, thank you. Thank you to counsel for their very learned arguments on a difficult matter. There is another matter that I have to deal with, but if you wish to be excused, you may be excused.